Okay, can you all hear me? Okay, thank you. We're here today for the appeal of MacLeod. I am lead administrative law judge Sarah Hosey. My panel members are here with me today. We have Judge Amanda Vasig and Judge Mike Lee. We are off the record right now, although the live stream is currently running. I'm going to go over some housekeeping items and answer any questions so we're all on the same page. I know we have some additional exhibits to go over, so we'll do that as well. Then we'll go on the record where our stenographer will be reporting this hearing verbatim to ensure we have an accurate record. Please, we ask that everyone speak one at a time and not speak over each other. Also speak clearly and loudly. When needed, the stenographer may pause the hearing and ask for clarification. After the hearing, an official transcript will be available on the Office of Tax Appeals website. Again, today's proceedings are being live streamed. The transcript and video recording are part of the public record and will be posted on our website under hearings. If at any time you have any questions, please ask me for clarification. I am the lead judge for the purpose of conducting this hearing today, but all three judges on the panel are co-equal decision makers. The OTA is an independent appeals body staffed by tax experts and is independent of the state's tax agencies. We have all read the briefs and examined the exhibits today. I'm going to cover the 5 issues. Number 1, did appellants make an Internal Revenue Code Section 170 bargain sale of the Palm Springs land? And who has the burden of proof on this issue? Number 2, did appellants have gain under IRC Section 731? If so, was there a computational error? And who has the burden on this proof? The burden of proof on this issue as well. Number 3, whether under the doctrine of res judicata, the FTB's exchange of information with the IRS causes it to be in privity with the IRS, such that it is now either barred from pursuing its proposed tax deficiencies, or if it's bound to accept the IRS tax deficiency for the 2006 tax year. Number 4, whether appellants have shown interest should be abated pursuant to RNTC Section 19104. And number 5, have appellants shown reasonable cause to abate the late filing tax return penalty for the 2006 tax year. These issues were discussed at the pre-hearing conference and set forth in the pre-hearing conference minutes and orders issued on September 6th. Do I have any questions regarding the issues today? Mr. Hammersley?
Yes, I agree with everything with the exception of the res judicata. It's the standard of law is an identity or community of interest such that the party was in privity would expect to be barred. It's not merely just the IRS communications. As I mentioned in the pre-conference hearing, the conformity statute, the disclosure statute creates an identity or community of interest. There's a recent 2002 Supreme Court, California Supreme Court authority that goes through that.
Okay, so conformity and disclosure.
There's several. We stated that there are several facts that give rise to privity, not just the IRS communications.
Okay, but we're familiar with that. I just would all change the language to include those as well.
Okay, thank you.
Okay, Mr. Modino, any questions about the issues?
No, we don't. Okay. Thank you.
All right, the exhibits that were discussed at the pre-hearing conference were appellants 1 through 22 and respondents A through DD, and those were admitted in the orders issued September 6th as well. And then Mr. Hammersley, you submitted additional exhibits 23 through 30. Mr. Modino, did you receive those? Can you hear me? Yeah. Did you receive those additional exhibits?
We have not.
Okay.
Oh, these are exhibits that were emailed a few days ago? Or
yeah,
yes, we have.
Last week.
I apologize. Yes, we have received them.
Okay, so you've looked at those. Do you have any objections to those?
No, we don't.
Okay. I will enter those on the record shortly. And then Mr. Hammersley, or Mr. Modino, you admitted exhibit EE and FF the same week, last week. Mr. Hammersley, did you have any objections to those 2 documents? Did you receive those?
I did.
It was a return.
As I understand, those were very recently received from the IRS.
Those were the FTB returns received. It's a printout for 2006 and an account transcript. Yeah, I believe it's.
One issue I had that part in the discovery proceedings, there was a surprise order that they wouldn't be able to spring new documents. And
I believe the.
Judge Margot was in support.
Yes,
What I'm saying is I'll waive that, seeing as though they just got them, they weren't in their possession. Sorry, that.
Yeah, Mr. Imardino, the returns received display, was that information part of the exhibits that we've had? Sorry, we're having some hearing, can you get a little closer to your...
Yeah, I had my mic
I
off.
heard you, but they just want to be able to...
Yeah, they were not part of the exhibits.
Okay,
May I speak to that, Judge Hosey?
yes.
Thank you. The returns received display printout that was submitted as Exhibit EE,
Yes.
Is a record FTB has of returns that are filed. It has had that information. Both EE and FF were submitted pursuant to the agreement at the pre-hearing conference that additional exhibits could be submitted by a date certain, and they were submitted by that date certain, as I believe, as were appellants or exhibits.
Okay, so it's my understanding, either of you, the return received display is just the line items of the dates that returns were submitted to the Franchise Tax Board?
That's correct.
And then the IRS account transcript is a summary of the activity between the taxpayer and the IRS for the for the 2006 tax year?
That's correct.
And Judge, if I may explain the exact nature of the issue. So during discovery, in the discovery orders and in the subpoena requests, the two categories of things we request are IRS communications and past documents. The documents, they did not produce any documents in response to the discovery or the subpoena. Instead, chose to cherry pick past documents and IRS communications in this issue of surprise as well. So I
understand your concern.
What you'll see, in the exhibits AA and DD that you referenced in your order, there's lots of IRS documents, IRS communications referenced in there. We didn't get any of them. So
This
rather than
information, I understand. Thank you.
Okay.
I'm going to go ahead and allow this just because the information, I mean, we understand that the two dates we already knew about, and then the account transcript is a summary of kind of what we have in the record already. So I don't think the information itself is a surprise. So
I don't have any objection to the information itself.
Okay.
It's the procedural issue.
All right, we're going to allow those in a minute. And then, Mr. Hammersley, did you have any other exhibits today that you wanted to?
No,
Okay.
no, Judge.
Thank you. Mr. Imardino, did you have any other exhibits today?
Per the discussion at the pre-hearing conference, the appellants did not admit all of their exhibits that they attached to their opening brief and their reply brief, and so those exhibits we also agreed would be part of the record.
I'm so sorry. Can you repeat that? I'm having a little bit of trouble hearing you.
I'm sorry. Is this better?
Yeah, thank you.
So during the pre-hearing conference, we discussed that the appellants had not attached all of their exhibits from their opening brief and their reply brief into their formal exhibit list.
Yes.
And so we agreed to include those exhibits in the record.
Yes, that was in the stipulation in the pre-hearing conference minutes and orders. That was stated as a stipulation, so I agree that we're on the same page there. Okay, and then Mr. Hammersley, it doesn't appear your witness is here today. We're going to not have Mr. Van Dam testify today?
That's correct.
Okay. So then we will have, you still want to have an opening statement, and then we'll have closing arguments. We'll just skip right to it.
Yeah, well, here's something I'd like to get to on that is, I've gotten permission from my client to testify as a material fact witness. I litigated the U.S. Tax Court case for them. I have firsthand knowledge of the facts. I interacted with respect to the interest abatement. I interacted with the Franchise Tax Board. I have personal firsthand knowledge of what they did. I'm willing to go under oath and testify to those facts. And I've been given, as I said, permission from my client. The Franchise Tax Board, as far as I know, will not be put under oath. And anything they say cannot be regarded as evidence. It's merely argument.
That's our understanding as well. Mr. Medino, do you object to us swearing in Mr. Hammersley so that any factual information that he would like to use as testimony sworn under oath for this case? However, any legal arguments will remain legal arguments, but any facts that he has personal knowledge about and testifies today, do you have any objections to that?
Yes, we do. During our discovery, our very lengthy discovery with the Office of Tax Appeals, the Office of Tax Appeals heard many of the assertions that Mr. Hammersley is making and found that they were without merit, and that going down the course that Mr. Hammersley desires to go down would not be relevant or be helpful to the hearing. Further, Mr. Hammersley had the opportunity to bring up the option of having himself as the witness and chose not to. And so this late in the game, for various reasons, we would object.
Mr. Hammersley, are there certain facts that you're concerned that are in dispute currently that you require testimony?
Sure.
From your personal knowledge that you have regarding?
The FTB's assessment throughout their briefs make wild allegations about what happened, what took place in the U.S. tax court litigation with the IRS. I have firsthand knowledge. It's completely fabricated. Never happened.
The IRS, the FTB's briefing relies solely on the documentation.
How about we move forward with the arguments, and if the panel has questions regarding any factual statements and the veracity thereof, we will swear you in and move forward that way. I don't think, just since we haven't considered it before the pre-hearing conference, I think we'll just move forward with the arguments. And then if we have any concerns, we can swear you in and get the testimony that way.
Excuse me. May
Yes.
May I be heard on that?
Go ahead.
If Mr. Hammersley were to be sworn in and testify as a witness, Franchise Tax Board would want evidence submitted into the record, credible and competent evidence that his client, that the appellants have in fact authorized him to speak and testify on their behalf today.
We'd be glad to do that.
We can cross that bridge when we get there. I think we'll move forward with the legal arguments, and if we have any factual issues that we're concerned about, we'll get to that. Okay, so you still want, Mr. Hammersley, a 20-minute opening statement, and then we'll go into closing arguments, assuming there's no questions from the panel?
Yes, I have one last point on that, Your Honor, or Judge. Regardless of whether the FTB wants to take an oath, they have a duty of candor to the tribunal under Rule 3.3 of the Professional Rules of Conduct. This is under Rule 1.01M, a tribunal. There's ALJs. So I just make that point clear.
Okay, I understand. And we're not, Mr. Imarduna is not being sworn in as a witness. We're just having legal argument on these issues. Is that correct, Mr. Imarduna?
That is correct.
Okay. Okay, and then the judges will have some time for questions if we have any. Are there any questions from the parties before we go on the record? Mr. Hammersley?
No, Judge.
Ready? Okay, Mr. Imarduna?
Judge Hosey, we would respectfully request that to the extent that we do not use all of our time in our opening statement, that any of that time be allowed to be carried over to our closing argument, and we would respectfully extend this same request to the appellants.
Yes, you can do that for sure.
Thank you.
Okay. Panel, you guys ready to go on the record? Okay. We are opening the record in the appeal of MacLeod. This matter is being held before the Office of Tax Appeals, case number 1809-3762. Today is September 21st, 2022, and it's 2:15 p.m. We're here in Sacramento, California. I am the lead administrative law judge, Sarah Hosey, and with me today are Judge Vasig and Judge Lee. All three judges will meet after the hearing and produce a written decision as equal participants. Although the lead judge will conduct the hearing, any judge on this panel may ask questions or otherwise participate to ensure that we have all the information needed to decide this appeal. Can I please have the parties state their names for the record? Mr. Hammersley?
Michael Hammersley for the appellants.
Shiro Imordino for the Franchise Tax Board.
Marguerite Meunier for the Franchise Tax Board.
Thank you. The issues we have in front of us today are whether appellants made an IRC Section 170 bargain sale of the Palm Springs land. Who has the burden of proof on this issue? Did appellants have gain under IRC Section 731? If so, was there a computational error? And who has the burden of proof on this issue? Whether under the doctrine of res judicata and other concerns such as conformity and disclosure cause bar FTB's proposed California tax deficiencies, whether appellants have shown interest should be abated pursuant to RNTC Section 19104, have appellants shown reasonable cause to abate the late filing tax return penalty for the 2006 tax year. These issues were set forth in the pre-hearing conference minutes and orders issued on September 6, 2022. Mr. Hammersley, does that sound accurate?
Yes, with the exception of the res judicata point that I made.
Can you get a little closer to your microphone?
Yes, with the exception of the res judicata complexity that I made earlier on.
Right, regarding res judicata conformity and disclosure issues.
Right.
Okay. Mr. Medino, is that accurate?
Yes, thank you.
Thank you. For exhibits, we admitted exhibits 1 through 22 for appellant and A through DD for respondent, the Franchise Tax Board, into the record via the pre-hearing conference minutes and orders issued on September 6, 2022. Mr. Hammersley, you've submitted exhibits 23 through 30 on behalf of appellants. Mr. Medino, do you have any objections to these documents?
No, thank you.
Okay. Exhibits 23 through 30 are now admitted as evidence into the record. Mr. Imardino, you have submitted exhibits EE and FF on behalf of respondent, Franchise Tax Board. Mr. Hammersley, you have any objections to these two documents?
Just the ones I registered previously.
Yes. Mr. Hammersley was concerned about new information this late in the hearing process. However, both exhibits EE, the FTB returns received display printout for tax year 2006, and FF, IRS account transcript for appellants for tax year 2006, have information in them that is in the record to date. So I'm going to allow these documents, overrule the objection, but we will consider all objections when weighing the evidence and making our decision pursuant to Regulation 30214F4. So, that being said, exhibits EE and FF are now admitted as evidence into the record. All right, Mr. Hammersley, are you ready for your opening statement?
Yes, I am, Judge.
You have 20 minutes. Any time you do not use, we will hold over.
Thank you.
Go ahead and begin.
So before I get into the substantive issues on this issue of the weighing of the evidence, I'd like to point out that in weighing the evidence, even though the OTA does not adopt the evidence code, Section 412 of the evidence code discusses the weighing of evidence with respect to weak evidence. So I'm speaking with respect to exhibits like they're just submitted, like the exhibits AA and DD that were past documents, that were all, rather than provide all of them as requested in the production request and the subpoena request, that they feel comfortable, the protection of the order. They don't have to, but what you do when you get that is the Cookston presumption, I'm sure you're familiar with, you cite it often, but also this evidence code 412. When you don't turn over, and if you look in exhibits AA and DD on the IRS communications and on the other pass folders and things referenced in there, and Judge Hosey, I know you worked at FTB, you're familiar with the pass system. There's lots of different folders and documents and stuff. We asked for those. All we got were exhibits attached to their briefs. We got no production on the request. So here's what Section 412 says. With respect to the way to be given to evidence, quote, if weaker and less satisfactory evidence is offered when it was within the power of the party, they have the yes. They have the sole possession of the past documents and the IRS communications. If weaker and less satisfactory evidence is offered when it was within the power of a party to produce stronger and more satisfactory evidence, the evidence offered should be viewed with distrust. Appeal of Don A. Cookston, cited often by the OTA. It is well established, quote, it is well established that the failure of a party to introduce evidence which is within his or her control gives rise to the presumption that if provided, it would be unfavorable. So that's the rest of the bargain they bought when they didn't turn over those documents. Their documents, and I'll point out, with respect to they're not authenticated, and they're not complete in many cases. Rob Exhibit X is a perfect example. Rob Exhibit X was whited out, not redacted in black, as I'll point out later. The line item that made their point in the brief, purportedly we paid 67% of the deficiency was disallowed to the IRS. It was 8.3%. They made that point. They cited Exhibit X, whited out the bottom and the top, and the line item description of the 33% where they got their 67. I've never seen such a thing. That evidence is completely unreliable. Exhibit Y, attached to their RRB, their reply brief, page 19 of 40, is that document, and you can compare the two. They whited out the sections that contradicted the argument they were making in their respondent's opening brief, citing Exhibit X. So the weight that's given to their documentary evidence should be 0. It's not reliable. And as I said, the exhibits that should be looked at there, Rob Exhibit X, which was R7, Rob Exhibit Y, which is R8, Rob Exhibit T, referred to as the smoking gun letter, that was withheld from us for a period of 5 years. That was issued on February 15, 2013. It was cited as Exhibit C in the IRS examinations report. The IRS would not give it to us. When we asked for it, they said the FTB protest hearing officers requested confidentiality. You'll have to get it from him. When we asked for it, we were repeatedly denied. It was finally attached to parts of it to the Exhibit T to the respondent's opening brief. That is not reliable evidence. Also, Exhibits 25 and 26 show the subpoena request, the two categories of documents, the past documents and the IRS documents, which are referenced repeatedly, as I said, in Exhibits AA and DD of respondents' briefs. All right, with that said, here we are 11 years into this protest, this appeal, 7 of which was in the protest, during the protest, just under 7 years. If you look at even the exhibits AA and DD, what on earth were you doing for 7 years? That all goes to the interest abatement issue. But the transaction is actually quite simple. And so I'd like to explain the transaction. The law is quite simple. There are only 2 federal income tax code provisions, 170 and 731, as Judge Hosey said. So the ownership structure, the respondent's reply brief, Exhibit AA, has a diagram of the ownership structure. Basically, the appellants owned, I think it was 58 point something percent directly and indirectly of MC Properties. MC Property owned NC Properties was a tax partnership. The LLC was a tax partnership. They owned 2 parcels of land that totaled 19.16 acres. On or about 2003, they entered into negotiations with the Palm Springs Unified School District to sell that property to them. The Palm Springs Unified School District is a 501 organization. To the extent there's excess value in the sale, there's a charitable contribution deduction. So the negotiations went on from 2003 and did not finally close until April 28th of 2006. There was a letter that threatened condemnation, and finally the taxpayer caved And that's referenced in Section 1.2 of the Purchase and Sale Agreement. Two things are referenced there, that it was under threat of condemnation, and it's a 1033 transaction. No one disagrees about that. Well, 1033 is either condemnation or threat of condemnation. And the sale then took place and closed on April 28th of 2006 for $10.558 million, I think it was. The taxpayer wrote contemporaneously in Section 1.2 of the Purchase and Sale Agreement that the value of the property well exceeds that $10.5 million, and documented that and the fact that it was on the threat of eminent domain. The problem here on the threat of eminent domain is the appraisals and all the IRS stuff that respondent relies upon. Respondent's closing letter before we filed the protest treated that transaction as a constructive condemnation. They said, you didn't give your property away. There's no donative intent. They took it from you. Well, when the IRS went and talked to the Palm Springs Unified School District after getting all of the FTB's arguments and Exhibit T and all the documents they sent to them, the Palm Springs Unified School District told them the exact opposite. It never went down that road. Well, how's it a 1033 transaction? So the witness, on this is switched their stories. Granted, it was a new person and at the Palm Springs Unified School District, but they were very adamant that there was no threat, despite the existence of this threat letter, and despite the fact that all the parties agree it was a 1033 transaction. So the witnesses supplying information to the FTB and the IRS are questionable. So the bargain sale transaction took place. As I said, it was a 1033 transaction. Procedural history of the case. This case started with the Franchise Tax Board. The protest got it right about the beginning of, we filed the protest at the end of 2011. They got it at the beginning of 2012. Not long after, there were some IDR requests, and then the IRS opened an audit. And the original notice of proposed adjustment we got quoted a typographical and grammatical error from the FTB's apes. So it was clear at that point we knew they were sharing information. We asked the disclosure office. They denied it. They got into this little debate about what a third-party contact is, and we said third party under the statute is anyone but the taxpayer. The question is whether you have to disclose it in 19504.7. They wouldn't answer the question. And as we know, Exhibit T, which was cited in the IRS examinations report, there were many communications. It's in those exhibits AA and DD. We now know. Even though we didn't get the documents, it's absolutely clear from the evidence in the record. They were talking regularly. And in Exhibit T, the legal analysis was written from the Franchise Tax Board to the IRS, which adopted their arguments. And then vice versa, when the notice of assessment was issued from the IRS, the FTB adopted their arguments. So there's a lot of coordination. That'll get to the privity issue. So as I said, what happened is when the IRS then issued their notice of deficiency, which is a 90-day letter, that's the end of the IRS controversy. You're now working with IRS appeals and the litigation section. If you want to pursue an appeal, you have to file a tax court petition. That's litigation. We gave you Exhibit 3 and 4 that show the docket and show the tax court decision. I don't know why on earth we are still calling this an IRS determination. An IRS determination is an IRS examinations, an IRS audit report. It is very clear that that is the decision of a court of competent jurisdiction, the United States Tax Court. So I don't know why we're talking about an IRS determination. We don't agree with the IRS determination. The IRS determination completely disallowed the deduction, which was reversed by the tax court. So, as I said, there's only two major code sections here. Section 170, I think 12% of the deficiency is attributable to that. The bulk of it, I think 88%, is attributable to the 731, specifically Revenue Ruling 81-242 theory. We're being taxed on a theory based on an article that the two attorneys from Franchise Tax Board that have argued the two cases they've had on this wrote. And the article, which is Exhibit 17, makes our case. It says it's a horrible policy, horrible rule, it should be done away with. But they argue that, because I'll get into that. When you look at the history of that rev rule, it was originally a taxpayer favorable ruling that GCM 38389 reversed and said Section 1033 and 752B operate independently. The problem isn't 1033, it's 752. Well, in 1991, regulations were passed in 1.752-1F that allowed liability netting that fixed that problem. The IRS has not litigated or even addressed in any administrative controversy have they taken a position in administrative guidance that 81-242 is still good law. And yet here we are, 88% of our deficiency is attributable to this theory that there's a transitory liability relief, that specifically when the replacement property was purchased on that Palm Springs Unified Sale District to qualify for 1033 treatment, that when the liabilities on the sale property were paid off, that you cannot view the replacement property transaction that are bookends for non-recognition under 1033 as part of a single transaction. And so we stop, and if you look in the middle and you cut it off, you have a transitory relief of liabilities that gives rise to a Section 731 gain, a deemed distribution. The Franchise Tax Board freely acknowledges that if an individual had done that transaction, there'd be no problem. This is purely a function of partnership, this proposed issue. If an individual had done that exact same transaction, there would be no gain, 731 gain. Res judicata. As I said, the tax court determination letter is not, the tax court April 30th, 2015 decision is not an IRS determination. It's a decision of a court of competent jurisdiction. The FTB had, well, let me back up a little bit. There are three elements to res judicata. It appears, I'm never clear what they've acknowledged or not acknowledged, but it seems like we've limited to this privity issue. There's three elements to it that you have a final judgment on the merits. The U.S. Tax Court opinion is that. It's not an IRS determination. And that it's the same cause of action. Well, the California Franchise Tax, or the Revenue Taxation Code, is derivative for Sections 1. It conforms to Sections 170 and 731. The tax for California state tax purposes is derivative of the federal income tax. The United States Tax Court looked at the exact issue of what are the federal income tax consequences, applying the Internal Revenue Code 170 and 731 to that exact same transaction for the exact same taxpayer for the same tax year. And the FTB does not want to follow it. If there's no federal conformity here and they do not have to follow this U.S. Tax Court decision, federal conformity is complete fiction. You'll never have a better case than this for them being required to follow Fed. So on the issue of privity, the last prong, the privity that the privity looks at, one of the things it looks at is mutuality. There is no question that had the tax court gone differently and gone against the taxpayer, that this taxpayer would be barred and would have to pay the state tax based on the federal tax liability, the decision of the U.S. Tax Court. The FTB is playing this when they put it pending federal and agreed to do that. They're playing this heads FTB wins, tails taxpayer loses game, and it's ridiculously bad policy. So looking at the issue of privity, this was recently addressed, establishing with respect to the final judgment, a stipulated tax court or stipulated court decision being a final judgment on the merits for res judicata purposes. There's a lot, I mean, it's well settled, but it was recently addressed in October 4th, Ninth Circuit opinion, Frank Lane Italian, Frank Lane Jr. and Alicia, BAP number EC-1247-SGF. And it confirms that well-settled law, and it cites California law, California Automobile Association versus Superior Court 50 Cal 3rd 658 at 664-665. On the issue, on the standard for res judicata or privity, there was a June 3rd, 2022 California Supreme Court opinion, Lindgren versus Eisenhower, fresh, and it again says here's the established standard. Identity or community of interest, quote, identity or community of interest such that the interest, yeah, sure. The standard for privity is an identity or community of interest such that the interest represented in the first action reasonably should have reasonably expected to be bound. Or the party in privity in the first act in the second action should have reasonably expected to be bound in the first suit. They cited the longstanding California standard in DKN Holdings, 61 Cal 4th at 826. So, I had mentioned it's not just the IRS communications that cause the FTB to be in privity, and there are lots of them. And they certainly had their chance to speak up and make their case. They did it in Exhibit T to their opening brief, argued their position, and then as the past documents, their Exhibits AA and DD show, they had early and often, they had lots of communications with the IRS. So the privity is established by the fact that the protest hearing officer, who happens to be the tax counsel here, reviewed the documents provided by the IRS and decided to put it pending federal, deciding that it was the same transaction, tax year, and federal income tax issues. That's an identity or community of interest. The conformity policy, conforming to federal law, is an identity or community of interest. In fact, it's derivative. The documents shared under the disclosure statute and the MOA that's required to do that could only lawfully be shared by the FTB and the IRS and vice versa if there was an identity and community and interest in the subject matter. There's a right to know and need to know. FTB had significant input and meaningful voice in the IRS matters by sending its legal analysis and regularly communicating. So that's the part about how much communication was there. We'd like to see all of the documents, and we don't have anywhere near those. We were never given. We have what they attached to their exhibits. That's all we have.
Mr. Hammersley, you have about a minute left, although it seems like we're getting into some arguments. So if FTB is comfortable with waiving an opening and just moving into arguments, you can use the 30 minutes of argument as well.
Probably makes sense, yeah.
Mr. Emergino?
That's fine, thank you.
Okay, so you'd just be moving into your arguments as well after Mr. Hammersley. If you, or Mrs. Monnier as well.
If you wouldn't mind, we might like just a short, few-minute opening statement.
Would you like to do that now, or would you like to, hold on, gotta stop my clock. Would you like to do that now, or would you like to wait until we finish with Mr. Hammersley? He's on issue 3 right now.
Well, we would defer to the OTA, although our request would be to do it now.
Mr. Hammersley, what are you
That's fine.
comfortable with?
That's fine.
We'll let them do a short, okay. FTB, please proceed.
Thank you. Yeah, I think it would help to have an opening, just kind of lay some foundation. Oh, no, thank you.
All right, turn my mic off. Can you just get a little closer so we can hear you?
Is this better?
Yes, thank you.
Sorry about that.
It's okay, thanks.
I think that having the opening would help lay a little bit of foundation and make it a little bit better. Okay, so thank you very much. I am going to discuss the Palm Springs land and the tax impact of appellant's partnership distributions. Then my colleague, Ms. Monnier, will cover interest abatement, res judicata, and the late filing penalty. The first issue in this appeal is whether appellants met their burden to show that they had a bargain sale of land. In a bargain sale, a taxpayer transfers property in a transaction that is part sale and part charitable contribution. Like most cases arising out of real estate transactions, this appeal is document heavy and the documents show what happened. The Palm Springs Unified School District was interested in purchasing land which was owned by appellants and others through LLCs. The school district was also interested in purchasing the adjacent parcel of land which was owned by an unrelated third party. During lengthy negotiations, the school district and appellants had multiple appraisals prepared. And as real estate prices rose during this period, so did the valuations in the appraisals. Appellants had 2 separate appraisers prepare a total of 3 appraisals which had valuations starting at $8.2 million and ending at $10.7 million. Similarly, the school district's appraiser prepared appraisals with valuations starting at $8.2 million and ending at $10.5 million. Ultimately, the parties agreed on a sales price of $10.5 million. The unrelated third party also sold the adjacent parcel of land for the same per acre sales price. During negotiations, appellants brought up the option of a part sale, part charitable contribution. The school district considered that approach, but ultimately made a fair market value offer and even had the purchase agreement specifically state that the sale was made at fair market value. Appellants originally filed a 2006 tax return did not report the sale of the land as a bargain sale. It was not until 4.5 years after the sale and in the middle of the audit that appellants filed an amended tax return and claimed that the value of the land was worth approximately $20 million, which is almost twice the sales price. To support this inflated valuation, appellants did not use either of the 2 appraisers that they'd used during the sales negotiations. Instead, appellants used a new appraiser who prepared a valuation for tax purposes. During the IRS examination, the IRS inspected the land and also prepared an appraisal. The IRS determined that the school district had paid fair market value for the land. Further, the IRS appraiser rejected the appellant's inflated $20 million appraisal, finding that it was inconsistent and biased. To get bargain sale treatment, 2 separate requirements must be met. First, the appellants must show that the value of the land was clearly out of proportion to the amount paid by the school district. Here, the evidence will show that appellants were paid fair market value for their land. Second, appellants must show that the excess value in the land was transferred with the intention of making a gift. Here, the law does not allow there to be intent to make a charitable contribution because the appellants accepted the school district's fair market value offer. Regarding appellants' assertions to the contrary, the IRS summarized its discussions with the school district as follows, and I quote, "The attorney and retired director stated that the taxpayer statements on the Form 8283 attachment are not accurate and misrepresent the school district's position at the time of the transaction." End quote. In addition, courts have been especially unwilling to allow taxpayers to unilaterally assert a gift occurred when they receive a fair market value offer, particularly in the background of eminent domain proceedings, such as in this appeal. As courts state, if the appellant did not feel the offer was fair, they had recourse through the eminent domain process, an option the appellants chose not to pursue. Next, I want to discuss. I'm going to discuss the tax impact of appellants' partnership distributions. Subchapter K of the Internal Revenue Code gives partners in a partnership significant flexibility. However, with that flexibility, Subchapter K also gives limitations. This appeal deals with one of those limitations, specifically the limitations surrounding a partner's basis in a partnership. When a partner puts something into a partnership or recognizes gain, their partnership basis increases. Similarly, when a partner takes distributions out of the partnership, their partnership basis decreases. A partner can take distributions out of a partnership without owing any tax as long as they have basis to cover the distributions. However, when a partner's distributions exceed their basis, Subchapter K requires that they recognize gain. In this appeal, appellants received cash distributions and the relief of partnership liabilities, which is also treated as a cash distribution. These distributions exceeded the appellant's basis in MacLeod Couch Properties LLC, and so the appellants are required to recognize gain. Regarding the portion of the distributions related to the relief of partnership liabilities, there is an IRS General Counsel memoranda directly on point. The General Counsel memoranda, or GCM, analyzes the impact of the relief of partnership liabilities in an IRC Section 1033 transaction such as we have in this appeal. The GCM specifically considers the appellant's position, fully analyzes it, and then rejects it, including the single transaction netting rule that Mr. Hammersley mentioned was passed in 91. Then 1 year later, a revenue ruling is issued which memorializes the analysis and determination in the GCM and which is consistent with the FTB's position in this appeal. Finally, there is discussion of a tax notes article which proposes a law change. This article was written by a tax practitioner in their personal capacity. Further, while not authoritative, the article reiterates that the law requires a result consistent with the FTB's assessment and that a law change would be necessary for a contrary result. And with that, I'll pass it to my colleague, Ms. Monnier. Thank you very much.
Ms. Bonnier, you have about 13 minutes.
Thank you. Good afternoon. Marguerite Meunier for Franchise Tax Board. And thank you, Mr. Imardino. I'd like to talk a bit about the concept of res judicata, interest abatement, and the Section 19131 late filing penalty. Res judicata is an affirmative defense. It must be proven, it's offered up and proven by the appellants. They must establish 4 elements to avail themselves of this defense. The evidence will show that the appellants have not established 3 of the 4 elements necessary to prove res judicata should govern the disposition of this appeal. And there is no requirement that FTB follow a tax court judgment with respect to tax year 2006. And similarly, the statutory right to interest abatement depends on the appellants having shown there was an unreasonable delay by FTB in working the underlying protest in this case. And here again, the evidence will show that there was no unreasonable delay or delay at all by the Franchise Tax Board. Further, the evidence will show that any delay that the OTA may determine is attributable to the appellants. And finally, with respect to the late filing penalty, and this applies only to the 2006 tax year, the record reflects a lack of evidence to establish reasonable cause for filing a late 2006 California return. So the evidence is clear that the Franchise Tax Board properly proposed the adjustments denying the charitable contribution deduction, proposing a Section 731 gain adjustment, and proposing a late filing penalty, and that the appellants have not met their burdens of proof to show otherwise, and consequently the OTA should sustain FTB in this case.
Okay, thank you. Mr. Hammersley, would you like to, you're into your closing argument time now, so you are able to cover, again, any issues before, go in depth, continue forward? No, rebuttal will be after FTB's argument. So your 30 minutes will start now.
Yeah, well, those are wonderful narratives, except they have nothing to do with reality. And the evidence will not show what evidence. I've cited specific evidence that shows exactly the opposite. With respect to the appraisals, those appraisals were 2 years. He didn't mention dates, 2 years stale. With respect to the GCM, that's a 1980 GCM, which reversed the private letter ruling, 79 private letter ruling that led to revenue ruling 81-242. How on earth in 1980 could Gerald Cohen, the chief counsel who wrote GCM 38389, who I wanted to testify as a witness but was denied, who thinks 81-242 is a dead letter? How on earth could they consider those partnership regs that were written in 1991 in 1980? What Gerald Cohen said was 752B is the problem, not 1033. The authors of the article, Mr. Amadino and his colleague, former colleague, suggest that to fix it, to have the single transaction, you would have to modify 1033. Well, the GCM says 1033 is not the problem; it's 752B, and 752B was fixed in 1991 in 1.752-1F. The problem's fixed.
I'm sorry. You're just listing these numbers off so fast. Could you please slow down a little bit?
Yeah. This is a theory that articles were written on. You can't tax taxpayers on theories. It's not right. I've spoken to the author, Gerald Cohen, of GCM 38389. He doesn't agree with it. They reference Revenue Ruling 2003-59, which was adopting the liability netting in a 1031 to say, see, it doesn't apply in 1033s. You need a 1033 liability offset rule like you have in 1031. You don't. They're just not getting it. The single transaction, and Gerald Cohen concedes that. And there was, by the way, before it was reversed, there was a lot of controversy at the IRS. The author of 2003-59 had told me that they were trying to include 1033, but as usual, the case is revenue rulings are limited to the facts that the questions that are asked. It was a 1031 question. Had they been allowed to extend it to 1033, they would have. So this is a problem that exists only in the mind of two franchise tax board attorneys. As I said, you cannot tax a taxpayer based on that theory, and that's 88% of the deficiency. So the charitable contribution is 12% of those two. So the bulk of it is this 81-242 theory based on their notions of what GCM 38389 was and was not. And they're wrong. They're flat wrong. And the authors of both revenue rulings have said that, and I'd like to have them here to testify. They tell you that. And the IRS has not cited that revenue ruling since it was issued. 40 plus years. He mentioned a revenue ruling. He didn't mention the date. It's 81-242. It was over 40 years ago. No one's been taxed on that except these two taxpayers that have come before you. All right, so with respect to these four elements of res judicata, I've laid out the elements of res judicata. And as I said, I was under understanding from the pre-hearing conference that the privity was the only element that was in question. Now all of a sudden we're reverting back to there's other elements that are in question. Well, I wish I've spoken to those, that the U.S. Tax Court opinion is a final judgment on the merits, and it's clear that it's the same cause of action. It has the same nucleus of common operative facts. So, respondent, if somehow we were to view the April 30th, 2015 U.S. Tax Court opinion as somehow being an IRS audit report, which is what an IRS determination is, I mean, that would be more in this fictional world, but the FTB's own pre-hearing conference statement said they would carry the burden of proof, not the taxpayers. Well, to the extent that their position is inconsistent with the U.S. Tax Court opinion on Sections 170 and 731, then they have the burden, not the taxpayer. There's a presumption of correctness in the U.S. Tax Court opinion. They just want to disregard a chief judge of the United States Tax Court. And they wanted to say, oh, it's just a stipulated decision, therefore it's really an IRS determination. The law is well settled. That's not right. Section 170, basically their position is based on a couple of things. Those stale those stale appraisals that, it was a rapidly rising market in 2003 to 2006, and the taxpayer kept saying, I'm not closing. The price is going up, the price is going up, and the appraisals show it. And we've already done this with the IRS. The issue was resolved based on a meeting on the battle of appraisals. Their appraiser was an IRS employee. Their appraiser did a drive-by. He doesn't live in California. He did not visit the Palm Springs area. There are a lot of things in the IRS examinations report that are not quite accurate. And as I said, the Palm Springs Unified School District completely changed their story. They told the FTB that, it was taken, that's why it's a 1033. They told the IRS that it never went down that road, it was completely voluntary. So there's a lot of things in the examination report that are not reliable. And based on that, and based on the strength of the taxpayers' appraisals from a qualified appraiser, the FTB auditor has acknowledged they don't have their own appraiser. They are trying to rely on an IRS appraisal, which was an IRS employee, and the FTB auditor has acknowledged we're not qualified. The FTB is not qualified to challenge appraisals. So let's leave that to the experts, the people who do that for a living. And we did that, and we did a battle appraisals with the IRS, and that's why only $800,000 of $9.577 million of disallowed deficiency charitable contribution deduction was ultimately disallowed. Because the appraisals prove it. That's what the evidence will show, specifically, not generally. Some of the exhibits point to, so where they sprung with this theory, they've stated throughout their briefs that we somehow paid 67% of the deficiency. Well, 800 over 9.577 million is 8.3%. It's not 67%. That's the whited out Exhibit X from their respondent's opening brief. They made it, that's a litigations memo. What that is, that was the appeals officer arguing to her boss, the chief counsel, who did not like their views. He thought there was weakness in the appraisals. He thought there was weakness in the witness credibility. That's why it went from a complete deficiency, a complete disallowance, to 8.3%. The whiting out in the arguments in the respondent's open brief used that to springboard to say that we paid 67%. What that is they were telling the chief counsel that they had a 67% chance of victory. Well, why do you concede and have the taxpayer pay 8%? So a lot changed. A lot of their information is really nowhere near accurate. And I was there firsthand, as I said. This is the issue I was talking about, testifying. They don't have firsthand knowledge. They're reading documents and giving a view from it. And I'm telling you, I was there. I can testify to what happened and what did not happen. I'm a material witness on that fact. My clients would not have been very happy if we paid 67% of the deficiency. So as I said, that's the whole idea of res judicata, that we're not going to come here and relitigate this battle of appraisals again. We've already done that once on the exact same transaction. We went through the appraisals. As I said, they don't have their own appraiser. They're relying on the IRS. They weren't there. It wasn't their appraiser. It was an IRS employee. We have an appraisal. In fact, we have a second appraisal from a woman named Rose Sweet. She wasn't certified. We went on and got another one, and it's close to the one that we have in the record. So they're looking at stale appraisals and saying those are contemporaneous. It doesn't take a genius to figure out that in a risingly rapid market like we've had recently again, that old sales aren't good value, aren't good information. The properties in our valuations were very close in time, and there were properties to support the $20 million value. They sold for way more, and it turns out the taxpayer was right when he put that in the purchase and sale agreement in Section 1.2. Just on the 81-242 issue, just to give you the exhibits, it's our exhibits 17, 15, and 16. 17 is the tax notes article, 15 is Rev Rule 81-242, and exhibit 16 is GCM 38389. On 81242 in the GCM, those exhibits tell you all you need to know, especially the tax notes article. Excuse me 1 second, please. I guess airplane mode doesn't kill that. I apologize for the disruption. So, yes, you mentioned the computational errors as well. Exhibit 11 is EUI's Section 731 computation. On the interest abatement, look, it took 7 years in the protest. 3 years after the April 30th, 2015 tax court decision was issued, took 3 years to issue the determination letter. We kept responding. That's in the correspondence that we submitted. We had asked again during discovery for FTB to say, is that all the correspondence? They wouldn't said, well, it's redundant to give our correspondence. We were on the other end of it. Well, then that's fine. Just say that that's it, that's true, accurate, and complete. And they wouldn't do that. I can tell you that's it. So if you look at the lack of communication, the lack of transparency, not giving us the Exhibit C, the respondent's opening brief Exhibit T letter, smoking gun letter, not giving us any of the documents in discovery, subsequently was reflective of what happened in the protest. They were trying to prevail on this Section 170 and 81242, and there just wasn't the facts of the law to do it. So it took 3 years. There was no communication between that 2015 to 2018 period. Take a look at the exhibits we submitted. The Franchise Tax Board Notice 2006-1, which was recently updated, or more recently updated in 2018-1. Those are the docketed protest procedures. Well, we kept asking for those to be followed, including a case development plan. We were ignored. There was no communication. There's a 2-year time frame for this kind of issue. As I said, it's a very simple fact pattern and very simple law. What on earth could have taken 7 years, albeit there was a brief hiatus for the federal tax matter. But still, on the interest abatement issue, that's not reasonable in any world. So I would take a look on those Exhibits 9 and 14. That's all the protest corresponded in nearly 7 years. Respondents Exhibit AA and DD, those are the past exhibits that they submitted, not all the past documents that are relevant. Exhibit 7X, Exhibit 7, which is Respondent's Opening Brief X, which is the whited out IRS document. Exhibit 25 and 26 and 7 are the show that they would not provide us with the requested IRS documents or past documents. Exhibit T is that February 15, 2013 smoking gun letter, which was Exhibit C to IRS's audit report. That was withheld for 5 years until it was attached as Exhibit T to the opening brief, to Respondent's opening brief. Exhibit 23 is Notice 2006-6, the docketed protest procedures, and Exhibit 24 is Notice 2018-1. On the delinquent penalty, I've explained those. That's been thoroughly discussed in our briefs. They just assess without asking any questions. It's very well described in our brief, but the deficiency was created from the position that the return of the 565 was filed timely. The taxpayer's CPA at the time and return preparer was terminally ill, and I've attached a brief to show his obituary, and he died, and it took some time. The return with the extension was 1 month late. So that's reasonable cause. And it's explained, as I said, explained thoroughly in the briefs. That's it, yeah.
Sorry, that concludes your arguments for now?
Yes.
Okay. Thank you, Mr. Hammersley. Mr. Imardino, would you like to begin your closing arguments?
Thank you very much. I'm going to discuss the sale of the Palm Springs land and the tax impact of the partnership distributions, and then my colleague, Ms. Monnier, will cover interest abatement, res judicata, and the late filing penalty. Initially, I want to address the burden of proof. Per the precedential OTA cases of Morosky and GEF Operating Inc., FTB's determination is presumed correct, and the taxpayer has the burden of proving it wrong. Similarly, for refund claims, per the precedential OTA appeals of Gillespie and Jolly LLC, a taxpayer bears the burden of proving entitlement to a refund claim. See also the OTA's regulation section 3219. Further, appellants have cited no law which would cause the burden to shift from the appellants to the FTB. Accordingly, the appellants bear the burden of proof in this appeal. Going to the bargain sale issue. First, I note that in the relevant law, the term condemnation covers eminent domain and is the term that I will be using going forward. In a bargain sale, a taxpayer transfers property in a transaction that is part sale and part charitable contribution. For a bargain sale, two separate requirements must be met. First, appellants must show that the value of the land was clearly out of proportion to the amount paid by the school district. Second, appellants must show the excess value in the land was transferred with the intention of making a gift. Going to the first prong of whether appellants have shown that the value of the land was clearly out of proportion to the amount paid by the school district. Notably, all contemporaneous appraisals, including appellants' own appraisals by two different appraisers, support that fair market value was paid for the land. In addition, the IRS physically inspected the land and also prepared an appraisal which determined that fair market value was paid for the land. Further, as discussed by the IRS in Exhibit V, the IRS reviewed the appellant's new appraisal, which valued the land at $20 million, and found that it was biased, inconsistent, and did not support the valuation. While this appeal deals with the threat of condemnation, that threat came out just 2 weeks before the purchase agreement was signed. So let's look at the year and a half during which there was no threat of condemnation, and appellants could have sold the land to third parties. And in fact, the school district even encouraged the appellants to accept any third-party offers. In Exhibit H, the appellant's attorney summarizes that the school district had informed appellants to, and I quote, not hesitate to accept offers from third parties because the school district may not ultimately proceed with the acquisition, end quote. The school district reiterated in Exhibit I that appellants are free to dispose of the property as they believe is in their best interests. Appellants had the opportunity to sell to any third parties who offered a better deal than the school district. But appellants did not sell to a third party and instead chose to pursue negotiations with the school district. Let's look at the negotiations between the parties and the appellant's own words during the final round of negotiations that led to the purchase price. Exhibit H is a July 2005 letter from the appellant's attorney to the school district's attorney, in which the appellant's attorney summarizes that the appellant called the school district and told them that he thought the value of the land to be $550,000 per acre, but wanted at least $600,000 per acre based on high interest from third parties. So $600,000 per acre is the high point that the appellants asserted in their negotiation posturing. And as we all know, the way negotiations work is that you ask for the best, each side gives a little, and you meet somewhere in the middle. And that's exactly what happened here, with the school district making a fair market offer at $550,000 per acre, an amount that even appellant's own July 2005 letter dated reflected fair market value. Appellants accepted this offer, and the sale closed at $550,000 per acre, which is a $10.5 million sales price. The unrelated third party also sold the adjacent parcel of land for the same per acre price. This is a sale that was fully negotiated and that closed at fair market value. The purchase price was equal to 98% of the appellant's highest appraisal and 100% of the school district's highest appraisal. Now, the appellant mentions the timing of the appraisals and that they were outdated. But the exhibits I just cited mentioned came from July, which is where the appellants mentioned that the property was worth, or July of 2005, where the appellants mentioned that the property was worth $550,000 per acre, but he postulated in negotiations that he wanted $600,000 per acre. That was July of 2005. Then, during August of 2005, the school district got an update to its appraisal, and that update was then modified in October of 2005. So in October of 2005, the school district's appraisal reflected a value of $550,000 per acre. And the purchase sale agreement was signed just 1 month later in November of 2005. Now, the appellants are using a date of April of 2006. That is a date that the sale closed. The purchase sale agreement was signed in November of 2005. And that is the date when the parties agreed on a price, and that's how especially commercial real estate transactions work. You sign a purchase sale agreement, the deal is set, and then there's a due diligence period for any real property purchase. Once the due diligence period is over, then the deal, then the escrow will close and the title transfers. But the agreement on price was in that purchase sale agreement. That was a binding legal document. If either party had not wanted to go forward with their obligations under that document, they'd be subject to breach. And again, in November of 2005, the school district had let the appellants know about the condemnation of the plan to begin condemnation process. If the appellants did not feel the school district's offer was fair, they had the option to pursue remedies through the condemnation process, but they chose not to. In Meyer Brewing, the taxpayer valued his property at $1.2 million, but accepted $900,000. In not allowing a bargain sale, the tax court stated, and I quote, "The taxpayer who negotiates for the best terms he can obtain in a commercial transaction cannot subsequently claim a deduction based upon any excess value of the contributed property," end quote. Also, as the court in Hope stated, and I quote, "Grover Hope now should not be allowed to claim that he consented to the settlement only because he would later claim a bargain sale and a charitable gift to the state," end quote. Similar to the taxpayers in Hope and Meyer Brewing, appellants engaged in lengthy negotiations which resulted in a fair market value price and are now precluded from asserting a bargain sale occurred. The facts demonstrate that appellants have not met their burden of showing that the value of the land was clearly out of proportion to the amount paid by the school district. Now moving to the second prong of a bargain sale, which is whether appellants have met their burden of showing that the transfer of any excess value in the land was made with the intention of making a gift. Importantly, this appeal deals with property sold under the threat of condemnation. Appellants deferred gain from the sale of the Palm Springs land under Internal Revenue Code Section 1033 by asserting that the land was sold under the threat of condemnation. Appellants also assert in Exhibit Q that the implications of the condemnation were so significant that the school district would not sign the charitable contribution form because the school district was concerned about being legally required to pay more for the land. These statements were made by the appellants under penalty of perjury. Now, under the case law, if appellants feel that they are not being offered enough for their property, then they must go through the condemnation process. Similar to appellants, the taxpayers in Hope inserted a clause in the purchase agreement that the taxpayer believes the value of the property exceeds the purchase price. The Hope Court rejected this clause and stated that such a unilateral statement cannot change the taxpayer's negotiated fair market value deal into a bargain sale. The appellants argue that they should be considered under the condemnation process for some items that benefit their position in this appeal, but not for others that do not benefit them. But appellants cannot have it both ways. In fact, the Hope Court discusses exactly the inappropriateness of the advantage appellants and the taxpayer in Hope were trying to obtain at the crossroads of the condemnation process and tax law, with the court stating that, and I quote, "The condemnation procedures should not be forced to compete with the tax procedures for the right to determine value in a condemnation case," end quote. Accordingly, if taxpayers felt the offer was too low, they had recourse through the condemnation process, which they chose not to pursue. So in conclusion, it is the appellant's burden to show that they met each of the two separate requirements necessary for bargain sale treatment, and in this appeal, appellants have satisfied neither. This leads to the second issue in this appeal, which is, did the appellants meet their burden of showing error in FTB's assessment that partnership distributions exceeded the appellant's partnership basis? As we already discussed, partners must recognize gain when distributions exceed their partnership basis. This includes not only distributions of cash, but the relief of partnership liabilities. This appeal deals with appellant's distributions from MacLeod Couch Properties LLC, also referred to as MC Properties LLC in various documents. Appellant's total cash contributions received and partnership liabilities relieved exceeded the appellant's basis, and therefore appellants have taxable gain under IRC Section 731. It is a purely mechanical result. Regarding the treatment of partnership liabilities in an IRC Section 1033 transaction, such as we have in this appeal, there are both a General Counsel Memoranda, or GCM, and a revenue ruling directly on point, which affirms the FTB's assessment in this appeal. In GCM 38389, the IRS considered thoroughly reviewed the partnership liability netting issue and specifically rejected the analysis set forth by the appellants. Now, in their opening, the appellants mentioned Regulation 1.752.1F, what's referred to as the single transaction rule. And so what this says is that when there's a single transaction, you net the impact to the partnership change in liabilities in that transaction. The examples given in that regulation are when you contribute property which is subject to a liability to a partnership. In this single transaction, there are multiple impacts to a partner's liabilities, and you net it. It also gives the example of a merger. When you have a merger, which is a single transaction, you net the impact on the partnership liabilities. But even though these some changes to these regs might have happened after the GCM still specifically analyzed the single transaction netting issue. And it said there's no way that you could have a sale of a property followed by a purchase of another property potentially years later, and you could say that's one transaction. And the OTA made a similar analysis in its decision in the appeal of Schaefer. And so 1 year after the GCM was issued, the IRS then memorialized the GCM's analysis and conclusion in Revenue Ruling 81-242. As the Ninth Circuit Court of Appeal has held, revenue rulings are entitled to substantial judicial deference, with the Ninth Circuit stating in McKnight Ranch that, and I quote, "It is well stated that where federal law and California law are the same, federal rulings dealing with the Internal Revenue Code are persuasive authority in interpreting the California statute," end quote. Also, while not precedential, the OJ analyzed this same issue in 2019 in the appeal of Scott Schaefer, and consistent with the revenue ruling, made a determination consistent with the FTB's assessment in this appeal, including analyzing the single transaction rule. In the briefing, the appellants also discussed the unitary basis rule, as discussed in Revenue Ruling 84-53. And this revenue ruling also supports FTB's assessment. This rule references the basis rules in IRC Section 705 and states that a taxpayer who has multiple direct interests in a partnership will only have one basis in that partnership. So the scenarios in the revenue ruling are where a taxpayer owns both a direct general interest and a limited interest in the same partnership. So while the taxpayer has two direct interests in that partnership, the taxpayer still only has one single basis in the partnership. This same issue comes up with disregarded entities. Say a taxpayer owns an interest in a partnership directly and also owns an interest in that same partnership via an entity that is disregarded for tax purposes. Since the disregarded entity does not exist for tax purposes, the taxpayer is treated as owning the disregarded entity's interest directly. So for tax purposes, the taxpayer has two direct interests in the same partnership, i.e., the interest the taxpayer owns directly and the interest the taxpayer owns through the entity which is disregarded for tax purposes. Now, in this appeal, appellants have a partnership interest in MacLeod Couch Properties, LLC, and accordingly have a basis in MacLeod Couch Properties, LLC. Other partnerships also have an interest in MacLeod Couch Properties. However, unlike the treatment of disregarded entities I just mentioned, these partnerships are not disregarded entities, but are separate taxpayers that have their own interest and their own bases in MacLeod Couch Properties per IRC Section 705. To the extent that appellants have direct interest in these other partnerships, appellants will have a separate basis in each partnership. However, nothing in IRC Section 705 or the revenue ruling says that these bases can be amalgamated. For these reasons, the appellants have not met their burden of showing error in FTB's assessment that partnership distributions exceeded the appellant's partnership basis. And the last item I wanted to cover has to do with the IRS settlement. So, Exhibit 11 is the IRS internal settlement, the document where the IRS discusses the pros and cons of going forward with the settlement. I note that as Exhibit X to appellant or to respondent's opening brief, we attached a copy of the schedule only. And the reason for this is that we had not yet received permission from the IRS to release their internal settlement analysis. And so working with FTB's general counsel, we figured out what would be permissible to be released, and a determination was made that that schedule alone could be released without the entire document. Subsequently, the IRS gave us permission to release the full document, and it's included in Exhibit Y. On page 19 of Exhibit Y, you can see the full analysis of the settlement between the taxpayer and the IRS. And if you go at the very top, it says the 2010 appraisal value is $20 million. The sales price was $10.5 million. The difference is amount claimed as a charitable deduction is a $9.5 million. That's on line 3. And then the next line, line 4, estimate of government's litigating hazard, 33%. And so the next line, charitable deduction for settlement purposes, $3.2 million. So the IRS, in their settlement of 33% concession, they allowed $3.2 million, and they disallowed approximately $6.2 million, or $6.3 million of the claimed charitable deduction. And then, as you can go through the line, you'll see deducted in 2007, deducted in 2008, deducted in 2009, a total of $753,000. And then it says carry over to 2010 based on settlement range. $2.4 million was carried over to 2010. There's an AGI limitation that took away $114,000. $2.3 million was used to offset the taxpayer's income. They had claimed $3.1 million, and so the resulting assessment was $800,000. You see that very bottom line, 2011 disallowance is $800,000 on that particular tax return. So they lost $800,000 on their 2011 tax return, plus the remainder. Because there was a total, the IRS disallowed $6.2 million, they allowed $3.2 million, and they used up that $3.2 million between 2007, 8, 9, and 10, and 11, and it got all used up in 2011, so they had to pay $800,000, or they had $800,000 disallowed. And this $800,000 figure comports with all the documentation in the case. Mr. Hammersley has conceded that it's $800,000 in 2011, but what hasn't been brought up is they lost $6.2 million of their claimed $9.5 million, or $6.3 million of their claimed $9.5 million charitable deduction. It's clearly a 67% taxpayer concession. And with that, I'll pass it over to my colleague, Ms. Monnier.
Ms. Monnier, you have about 20 minutes.
Thank you. I was just going to ask you for that number. Okay. Thank you. Good afternoon. Marguerite Monnier for Franchise Tax Board, and I will be addressing the issues of res judicata, interest abatement, and the late filing penalty. Turning first to the issue of res judicata, it is appellant's defense to the adjustments and the attendant penalty, which are issues, I believe, 1, 2, and 4 set out in the pre-hearing conference minutes in order. In other words, that Franchise Tax Board is bound by res judicata to follow the tax court judgment for the 2006 tax year. That position is unsubstantiated by the law. And before I talk about what res judicata is, I'd like to talk about what it is. It is not, as appellants assert, a conformity issue. It's not entirely clear the context in which appellants are using that term today. If they are using it in the term that we often understand it at Franchise Tax Board, which is that we adopt as our own state tax laws specific Internal Revenue Code sections, we say that we have adopted them by conformity. So there is that conformity, and that is unrelated to the concept of res judicata. If the term conformity is used today to mean a resulting action by the Franchise Tax Board that flows from what's called a final federal determination pursuant to Revenue and Taxation Code 18622, that is also not relevant to the concept of res judicata. And I will speak a little bit more about 18622 later in my discussion of res judicata. So what is res judicata? It's an affirmative defense, and the burden of proof to establish entitlement to that defense rests with the party who is asserting it. And in OTA's February 4th, 2021, order regarding request for subpoenas for documents and witness testimony. On footnote 2, the OTA noted the appellant's assertion that it was their burden of proof on this issue, and the OTA agreed with that. And as the OTA recited in appeal, its precedential opinion, Appeal of Millennium Dental Technologies, a 2019 opinion, the party wishing to assert the affirmative defense of res judicata must establish the following 4 elements. First, that the parties in both actions are identical or in privity. Second, that a court of competent jurisdiction must have rendered the first judgment. Third, the prior action must have resulted in a judgment on the merits. And fourth, the same cause of action or claim must be involved in both actions. With respect to the first element, obviously there's no identity. There's no identity of parties because it was the Internal Revenue Service at the federal level and it is Franchise Tax Board at the state level. There is also no privity between the IRS and the Franchise Tax Board. As FTB discussed in its opening brief, the California Supreme Court defines privity, or a privy, as one who, after rendition of the judgment, has acquired an interest in the subject matter affected by the judgment through or under one of the parties, as by inheritance, succession, or purchase. So, in other words, what we're talking about is someone who, quote, stands in the shoes of that first party. FTB does not have such an interest. There is nothing in the record that indicates FTB had any influence on or directed the Internal Revenue Service's actions, either during its examination or subsequently during the tax court litigation when the matter was conducted or overseen by the IRS Appeals Office. What there was information sharing, which is authorized by agreement between the Internal Revenue Service and the Franchise Tax Board. And that is all it is. It is a sharing of information. It vests no interest in either party in the outcome reached by the other party. And so there is no identity of parties and there is no privity. With respect to the second element, Franchise Tax Board acknowledges that the U.S. Tax Court is a court of competent jurisdiction. That element is not in dispute. And moving on to the third element, which is that there must have been, in the first action, a judgment on the merits. Here it's instructive to look at the appellant's Exhibit 10 to its opening brief, to their opening brief, and note the first, I think it's 7 words of the judgment, pursuant to the agreement of the parties. This was not a matter in which the tax court considered the merits of either party's decision and applied relevant law to reach a judgment. It was an acceptance of an agreement negotiated between the Internal Revenue Service and the appellants, and as we have just heard Mr. Imodino explain, the Appeals Division of the IRS determined that it would settle for 33%, allow 33% of the claimed deduction, based strictly on hazards of litigation. That is not a judgment on the merits. You can see that also if you look at the tax court docket. It is one of the plaintiff's additional exhibits, one that we discussed at the beginning of the hearing today. There are very few entries on that docket. There's nothing on it, nothing substantive between the filing of the action in tax court and the entry of the judgment. And that confirms the fact that the tax court itself took no active role in the review of or disposition of the issues on appeal there. So they have not established the third element either. they have failed equally to establish the fourth element, that the same cause of action or claim must be involved in both actions. Now here we have to take a step back and look at the factual difference between the taxpayer's position and their amended return filed with FTB in October of 2010 and the same amended return filed at the federal level at that time. The Franchise Tax Board processed and accepted the 540X, the amended return that the appellants filed, the one in which they claimed the charitable contribution deduction, which was subsequently disallowed as shown on the Notice of Proposed Assessment. If, however, you look at the federal account transcript, that's Exhibit FF on page 2, you will see that in October of 2010, the appellants did file an amended return and that the IRS disallowed that claim. In other words, there was never a charitable contribution deduction allowed at the federal level for the 2006 tax year. And the third way to cross-check that is to look on the first page of the account transcript, and you see that the federal AGI is that's around $4,200. It's the same amount listed on the 540X as the amount that was reported on the original 1040, on the original federal return. So there could not have been an adjudication or an issue of the charitable contribution deduction between the IRS and the appellants for the 2006 tax year. It was never allowed. It was not a part of the negotiated settlement. Likewise, with respect to the Section 731 gain issue, the record in this case is devoid of discussion or evidence that indicates the IRS considered the Section 31 gain issue for this tax year. So there has not been symmetry or identity between the causes of action or claims that were resolved at the federal level and what is in dispute before you all today. Appellants have failed to establish elements, as I have them numbered here, 1, 3, and 4, for res judicata, and it is not applicable in this case. And a finding that there was no res judicata is consistent with Board of Equalization precedential opinions, starting with the appeal of Der Wiener Schnitzel in 1979 and followed by appeal of Bertrand in 1985, and the OTA adopts this view as well. In Millennium Dental Technologies, in footnote 13, the OTA noted a plaintiff's objection, a comment regarding an objection to a proposed penalty, and noted that the IRS had not assessed a penalty. The OTA went on to note that the FTB's assessment was proper in that case, and that the Franchise Tax Board does not have to follow IRS actions, and cited to Der Wiener Schnitzel. Further, if you would look at the January 22, 2020 orders re-discovery that the OTA issued in this appeal, and look at footnote 3, it is instructive. Appellants have cited no authority for their claim that Franchise Tax Board is bound to accept the Internal Revenue Service's 1/3 concession, parens, much less to treat it as a total concession, as appellants demand, and the law is clear to the contrary, with cites to Revenue and Taxation Code 18622A and to appeal of, I think it's Giselle, 80 SBE 035. And then finally, if we look at uncertainty as to how this IRS judgment would translate to the Franchise Tax Board, the uncertainty there is reason enough to disregard the idea that it could be a document that would govern the outcome of this appeal. Because there's no 731 issue or 2006 issue at the federal level, there was no charitable contribution allowed. How could you allow 1/3 of a proposed deduction that wasn't even part of that? And since there could not be an effect on the proposed adjustments or additional tax. So the appellants have failed to establish that res judicata should be applied in this appeal with respect to the 2006 tax year. When I said I would double back to 18622 on this topic, the conformity that FTB has, and under 18622A, when FTB issues a proposed assessment that results from a federal action, it's presumed correct and the burden is on the taxpayers to prove that it's wrong. However, we know under Der Wiener Schnitzel that neither the OTA nor the Franchise Tax Board is bound to follow the Internal Revenue Service. And this is not a federal action assessment. It does not result from the work and the determination of the Internal Revenue Service. And I would just make a side note there that a final federal determination, and when we talk about an IRS determination, it does include a tax court judgment. 1862D defines a final federal determination as defined in 6203 of the Internal Revenue Code. And then if you go to the attendant regulation, and I believe it's Revenue Ruling 2007 I'm sorry, I can't remember the last numbers. Well, actually, that part probably isn't relevant there. What it says is what's on the account transcript is evidence of the final federal determination, and it's a point where there is no longer any appeal or action that can be taken by the appellant. So, of course, that would encompass the terms of a settlement. And so, to turn now to interest abatement. Here again, the appellants have the burden of proof, and we know from the Office of Tax Appeals Precedential Opinion in Appeal of GEF Operating Inc. that to establish an abuse of discretion, the appellants must show that in refusing to abate interest, that the Franchise Tax Board exercised its discretion arbitrarily, capriciously, or without sound basis in law and fact. And this, the appellants have not done. Although interest abatement is authorized in limited circumstances, appellants haven't showed entitlement to it in this case. FTB diligently prosecuted the protest since it was filed. It was filed towards the end of, the protest was filed towards the end of 2011, and FTB wrote promptly in January of 2012 to say we have the appeal, the protest, it's being assigned to the protest unit, and received a request then in response from appellants asking to have the protest docketed. So it took a little time, got it docketed, and then the first protest hearing officer promptly issued a set of information and document request, an IDR letter, and that was followed later in 2012 by a response from appellants asking to have that protest hearing officer switched out for a conflict of interest. And there's no record in the file that indicates whether FTB made any decision on the merits, whether there was any actual conflict of interest, or to avoid the appearance of any. There was a second protest hearing officer assigned to this case, and he, in early 2013, sent out IDRs and responded to the appellant's request since the first January 2012 letter, saying, well, we may need to put this on hold because the IRS is looking at these same issues. And so while FTB then said, well, there are some issues perhaps we can go ahead on, maybe there are others that will have to wait, And the bottom line is that the Franchise Tax Board accommodated the appellant's request to wait until there was a, quote, final federal determination before it finished its work on this protest. And it didn't happen until July of 2015. FTB was advised there had been a judgment, and it took almost 2 years after that, waiting for IRS documents to determine the extent to which that federal judgment would affect the outcome at the state level. And specifically in the July 16, 2015 letter from the appellant's counsel, or from their representative, he represented that both the charitable contribution deduction issue and the 731 issue were covered by that judgment. As it turned out, and as I said, it took FTB almost 2 years, until 2017, to determine it had all the federal documents and that there wasn't the overlap, and further that in any event it was not required to follow what the IRS did. After that, the protest hearing was held in May of 2018. The notices of action were issued, I don't know, a couple weeks after that. So throughout the entire time period of the protest, FTB worked with the appellants to accommodate them and to keep working on the protest as possible. Finally, with respect to the Section 139 late filing penalty, if you see on Exhibit EE, the appellant's 2006 California return was filed November 29th, 2007. It was due April 15th, so it was more than 7 months late, and the penalty was applied. It's applied automatically under the law. Since no return had been filed during the extension period, there was no extension with respect to appellants, so it was properly computed at the maximum 25% rate. The appellant's assertion in their reply brief, the reason it was late is that the representative preparing the return had died, is unsupported by any documentary evidence in the record. There is nothing to show whether he was their representative, whether he was preparing the return for that year, when they learned that he would be unable to complete that return so that they could file it, and if so, what steps they took to ensure that if he couldn't, that someone else could prepare it so that they could meet their filing obligation. And so, for a failure of proof, they have not established that that reasonable cause exists to abate that penalty. Thank you. Mr. Mardino and I, this concludes our argument. We're happy to address your questions. Thank you.
Okay, thank you. I am going to check with the panel and see if they have any questions before we move forward with some rebuttal time. Judge Vasig, do you have any questions?
I do not. Thank you.
Judge Lee, do you have any questions?
No questions. Thank you.
Okay. I'm going to go ahead and deny the request for testimony since we have the documents and, well, it's a late request, and we didn't have any questions regarding the factual circumstances.
I'm sorry, what testimony would that be?
Oh, you just requested that you could be sworn in and testify yourself as to personal knowledge, but I just don't think we need that at this time.
There's been material fact statements back and forth by both sides this entire time.
I think we have.
But I'm willing to go under oath, and I have firsthand knowledge.
Yeah, we're not going to need that today, but thank you. I appreciate it. We will go ahead, though, with some rebuttal time, if you'd like some. Make sure I just have everything here. Yes, you have time for some final statements if you'd like to.
How long
Mr. Hammersley.
do I have?
Go ahead.
How long do I have, Judge?
Oh, yes, you have 20 minutes.
Okay. Well, that's why this protest took 7 years. No matter what we say, no matter what evidence we put into the record, they read a script, and they just say, no evidence, we didn't prove. They say the burden of proof is on us. Well, I've explained thoroughly why the burden of proof shifts from the U.S. Tax Court decision. 18.622, if you look at Wiener Schnitzel, Giselle, McAfee, Those cases all deal with an IRS audit report. The case law I gave you on the recent Ninth Circuit decision and the California Supreme decision cite well-settled law, a stipulated court decision, and from a settlement agreement in litigation. Once you file a U.S. tax court petition, it's litigation. You're done with the IRS when the 90-day letter is issued. They're their opposing party in litigation. So I can't even begin to say how wrong that was on the law on several points and how wrong on the facts. Adopt the law and those facts at your own peril. It's just flat wrong. The documents show it. I have testimony. I have firsthand observed the true facts. So 18622 is not accurate here. There's never been a case where I'm aware of where the FTB refused to follow a U.S. tax court decision that was pending federal on the same taxpayer for the same year for the same transaction. On the issue of the zero in 2006, it carried over to the subsequent years. They have no idea what they're reading in those documents. I negotiated that settlement. All but $800,000 of $9.577 million was allowed. They took the benefit of that charitable contribution deduction. Those are the facts. They don't have any firsthand knowledge to the contrary. They're reading stuff they don't understand. On res judicata, that law is not correct. There's no identity required. As I wrote you the quote, it's an identity or community of interest. That's the law, and it's very broad, and if you look at the case law of all of the facts that have been viewed to have an identity or community of interest, I told you, they said we didn't establish that there was an identity of interest. Well, they follow the same law. They could only have exchanged documents, which they did, if they had an identity or community interest in the MOA and the disclosure statutes. They didn't just send documents and exchange it. If you look at the exhibits AA and DD, they talked often, and Exhibit T, the smoking gun letter that they wouldn't give us for 5 years, was the legal arguments on 731 and 170. I was there. The IRS laughed at the 81242, just like the former chief counsel who wrote the GCM. They don't think that's good law, and they say, and the IRS, by the way, wasn't sharing anything with us. We had to get that ultimately from the FTB, from what they would disclose in their exhibits. So we were just as in the dark with the IRS. So why would there be anything? The analysis they're pointing to, they keep saying that Exhibit X, which was whited out. So you compare the other redactions. They're all blacked out in normal redaction mode. Look at the arguments made in the responding's opening brief that refers to that Exhibit X. He's making the 67% argument there. We didn't pay 67%. It's flat wrong. And if he had left those paragraphs above and below in the line item description, that argument would not hold. It's contradicted by the information that was removed, was whited out. Why would you white out information? You said you were waiting on IRS approval. That they had those letters for a long time. Why did you put it in there at all? And if you did, when you put it in, why didn't you redact it in normal fashion to let people know that there was something removed? So, on the rest of the law, the 81242, I've already testified or argued how that works and doesn't work. They just categorically do not understand the law or the facts. And no matter what we say or what we write, and that's why we've had to write volumes in this case, and we'd have to spend inordinate amounts of time to try to get the rest of the documents, the rest of the past documents, the rest of the IRS documents that they just selectively chose to put little pieces in. If you look at Exhibits AA and DD, their own documents, you will also see that there's a reference in there that says that the IRS, the tax court decision, after speaking with the IRS, was decided on the merits. It wasn't litigation hazards. They had 67% chance of winning, is what it says in that minute. The reason they settled at 8.3% is because their appraisal was horrible. It was from an IRS agent, and our appraisals showed the value and supported it. And because their witness, as I said, in the Palm Springs Unified School District, switched their story and was completely unreliable. Their case on the merits was terrible. And that's why it was settled at 8.3%. 67% is a fiction. And it's the carryover, I guess, that they don't understand how that works. The bottom line, $800,000 of $9.577 million was all that was disallowed. That's 8.3%. It's not 67%. So I don't know what to tell you. Read the documents. I'd love to give firsthand testimony under oath. I'm not able to do that. I'd love to have other witnesses testify about 81-242, what it means and what it doesn't. You can read their own article. It makes all the arguments that it's not good law. So they'll say that's not authority. It sure as heck is a statement against interest or an admission that our position is well supported. So when you're looking at the weight of evidence, consider all those things. They said that we didn't submit any evidence that the CPA had died. I submitted his obituary that referenced that he had a long-term illness. There was no dialogue. When you don't have communication with a taxpayer for 7 years, and you can see from all of the emails that I put in, that's it, over 7 years. When you don't have communication and you hide your actions in violating 2006-6 and transparency policies that this OTA is under as well, when it's going to take a long time and you're not going to get it right. If you would talk to the taxpayer and you would listen and you wouldn't keep repeating the same script no matter what they say or what they give you, then it wouldn't have taken 7 years. It took 2 years with the IRS because finally we got to a point where they realized the appraisals were bad, that the IRS appraisal was bad from Mr. Power, the IRS employee, and that their witness on all those statements that were reiterated here were not reliable or accurate. So the credibility and the weight of evidence matters. Narratives are just that. They're useless statements unless they're supported by documents. And they're citing documents to say they're supported. I'm trying to tell you that's not what those documents say, and my testimony can enlighten that because I was there and I'm the one who negotiated several of those documents. That's all we have to say.
Okay, thank you. I'm just going to check with my panel again to see if there's any questions before we submit the case. Judge Vassie, you have any questions?
I do not.
Judge Lee, any other questions?
No questions, thank you.
Okay, then we are ready to submit the case today. The record is now closed. This concludes our hearing, and the panel will meet and decide the case based on the exhibits and arguments presented. We will aim to send both parties our written decision no later than 100 days from today. Thank you all for your participation. The hearing is now adjourned. Thank you.
Thank you.
Very much.